Hello everyone, and welcome to this Federalist Society virtual event. I'm Caroline Bryant, and I'm the Associate Director of Practice Groups at the Federalist Society. Today we're excited to host this webinar titled Executive Orders, Faithful Execution or Legislating from the Oval Office. This is the first webinar of a series on theories of presidential power leading up to the Federalist Society's Executive Branch Review Conference on May 7th, and registration for that event is now open on our website. Our moderator today is Beth Williams. Beth is a board member of the United States Privacy and Civil Liberties Oversight Board. Prior to her board service, Ms. Williams was the Assistant Attorney General for the Office of Legal Policy at the United States Department of Justice. Prior to becoming Assistant Attorney General, Ms. Williams was a litigation and appellate partner at a national law firm where her practice focused on complex commercial, securities, and First Amendment litigation. If you'd like to learn more about today's speakers and moderator, their full bios can be viewed on our website, fedsoc.org. After our panel gives their presentation, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A feature at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinions today are those of our guest speakers, not the Federalist Society. With that, Beth, thank you so much for joining us, and the floor is yours.
Great, thank you. Well, good afternoon, and thank you, Caroline. It's always a pleasure to participate in the Federalist Society's programs, and that is especially true today as we virtually kick off the 2025 Executive Branch Review Conference with this terrific panel. So I'll start by introducing our experts, and then each will have time for their opening statements, followed by an opportunity to respond. Then we will have some moderator and audience questions. So please, as you're listening to our experts, feel free to type your questions, as Caroline said, in the question and answer function as you think of them, and we'll try to get to as many as we can. So with that, I will introduce our first speaker, who's Professor Alon Werman. Professor Werman is the Julius E. Davis Professor of Law at the University of Minnesota Law School, where he teaches administrative law and constitutional law. He writes primarily on the 14th Amendment, administrative law, separation of powers, and constitutionalism. He is also the author of the book, A Debt Against the Living, An Introduction to Constitutionalism, as well as The Second Founding, An Introduction to the 14th Amendment. His next book, The Constitution of 1789, An Introduction, is forthcoming from Cambridge University Press. In his spare time, Professor Werman practices law with the firm Tully Bailey and has litigated a variety of administrative law and constitutional law cases across the country. Next, we'll hear from Professor Richard Pierce. Professor Pierce is the Lyle T. Alverson Professor of Law at the George Washington University Law School. Professor Pierce has written more than 20 books and 125 scholarly articles about administrative law and government regulation. His books and articles have been cited in numerous court opinions, including more than a dozen opinions of the United States Supreme Court. He's testified several times before Congress on regulatory issues and on Social Security disability decision-making. He's also testified as an expert on energy markets in agency court proceedings. Professor Pierce has served as a consultant to numerous organizations, including the World Bank, the Organization of Economic and Cooperating Development, the Federal Energy Regulatory Commission, and the Agency for International Development. Before teaching law, Professor Pierce worked in the finance department of General Electric and practiced law with a Washington, D.C. law firm. He also served in the U.S. Coast Guard. Finally, we have Mr. John Malcolm. Mr. Malcolm is the Vice President of the Institute for Constitutional Government and the Director of the Meese Center for Legal and Judicial Studies and Senior Legal Fellow at the Heritage Foundation. Before being named Director of the Meese Center in July 2013, Mr. Malcolm spearheaded the center's rule of law programs. His research and writing as Senior Legal Fellow focused on criminal law, immigration, national security, religious liberty, and intellectual property. In addition to his duties at Heritage, Mr. Malcolm is chairman of the Criminal Law Practice Group of the Federalist Society and chairman of the board of directors for Boys Town, Washington, D.C., which provides homes and services to troubled children and families who are edging toward crisis. Before joining Heritage in 2012, Mr. Malcolm was general counsel at the U.S. Commission on International Religious Freedom, as well as a distinguished practitioner in residence at Pepperdine Law School. He also served as executive vice president of the Motion Picture Association of America and as a deputy assistant attorney general in the Department of Justice's Criminal Division from 2001 to 2004. We're delighted to have this very impressive panel. And with that, I'll turn it over to Professor Werman to start.
Great. Well, thank you so much for having me. And I want to apologize in advance if my voice gives out. I was just teaching, and I suppose I got carried away this morning doing that. So I thought the way we would start, or I would start, is explaining where executive orders fit in various theories of presidential power. And I'm going to start conventional and maybe end a little bit controversial. So the prevailing formalist theory of executive power, and I disagree with this theory, okay, but I'm going to lay it out, is that the grant of executive power to the president is a residual grant of all power that is executive in nature, which you can figure it out simply by the nature of the power or some indication of it if the monarch in England before the Constitution exercised the power. That's some indication that it's executive in nature, and that this is where the president gets a lot of powers that are otherwise seemingly missing from the Constitution, especially in foreign affairs. Executive agreements, treaty terminations, recognition, instructing and recalling ambassadors, and so on. But also in the domestic sphere, where does the removal power come from? Where does the power to direct them come from? The theory would be if it's executive in nature and not otherwise distributed or limited somewhere else in the Constitution, then it belongs to the president. So, Article 1, Section 8 actually has most of the limitations. It's often thought that the Constitutional Convention enumerated power to limit the national government's power. That's not why they did it. That may have been the effect, but actually they did it because they wanted to limit executive power, right? If you want the president not to exercise all of these royal prerogative powers that the monarch historically exercised, where do you give them? You have to give them to Congress. And so you have to enumerate, you have to specify Congress's powers over, I think something like over half, and I think substantially more than that, are historically royal prerogative powers. Okay, so how would executive orders fit in this? Well, the power to issue what were called proclamations is a royal prerogative described in Blackstone, not otherwise limited in the Constitution, and so it would be vested in the executive by virtue of this grant. And so here is I have this up here from Blackstone. He describes the king as the fountain of justice, and from that we may deduce the prerogative of issuing proclamations. These proclamations have a binding force when grounded upon and enforce the laws of the realm. Lawmaking is the work of the legislature, yet the manner, time, and circumstances of putting those laws in execution must frequently be left to the discretion of the executive magistrate. Therefore, the proclamations are binding, where they do not either contradict the old laws or tend to establish new ones, but only enforce the execution of such laws as are already in being in such manner as the king shall judge necessary. Okay, so that's like a pretty good origin of this power to issue executive orders. Note a few things about it, by the way. It has to carry into execution existing laws. It can't contradict the laws. It can't tend to be the creation of new laws. That still belongs to Parliament or Congress. Okay, now I started off by saying I reject the prevailing formalist view. So what do I think the actual answer is under the Constitution? Though even here, it's not exactly what I think, but I'm getting there. A much better account is that the executive, in my view, and most formalists disagree with me, is that the executive power is a grant of a single power. It is not a residuum, but it is a grant of power. So it doesn't merely identify that there shall be a president. It's not a residuum. It is a grant, but of only a single grant, the power to oversee the execution of the law. I think that is what they understood when they used the phrase executive power. This is where the power to execute law actually comes from. And so how would executive orders fit? Well, it was historically understood that the appointment power was an essential element of this power to carry law into execution. Okay, so when you say what is the executive power that the chief magistrate has, it's the power to oversee the law, the execution of the laws, which requires assistance because one person unaided can possibly execute the laws alone. And so the power to appoint people to help was understood to be part of the executive power. And incidentally, so was the removal power, because the power to remove was incidental to the power to appoint. If for no other reason, you could make a new appointment, okay? This is arguably how you get the removal power, by the way. This is going to be the subject of May 7 on the panel on Humphrey's executor, which I'll be participating in, and so I'm not going to say too much more, but you can derive the removal power from this. And I think the power to issue executive orders, okay? Even if it's just a grant of law execution power, okay, and not a residuum, it doesn't mean law execution is a thin power. It could be a thick bundle of related authorities that together make this power of law execution, including appointments and removals, as I just said, because nobody can execute the law alone. So in its nature, it includes the power to appoint. And they said this. I'm not just making this up. Lots and lots of people thought the appointment of officers was part of this executive power. Of course, it's limited in the Constitution with the Appointments Clause. So you could argue that the proclamation power is also part of this bundle. The power to oversee the execution of the law includes appointment, removal, and this proclamation power. Okay, this executive order power, if you will. You can't make new laws and so on, but that power is still there. Okay. Now, what do I really think? Now, here's where I'm going to start being controversial, and everybody could tell me why I'm wrong, or we can talk about something else entirely. Maybe the issuance of executive orders is not actually a power at all. Anybody could talk. Anybody could bark orders. Okay, I could write up something and send it to Secretary of the Treasury, Scott Bessent, ordering him to do something. I could even call it an executive order. Anybody could do that. The question instead is the obligation of the officer receiving the order to obey. Now, one might say, well, the president, because he's the president, the officer has to obey. But I'm actually not sure. I actually think the only obligation on the part of principal officers to obey the president is to give the president their opinions in writing about their duties of their respective offices, how they're executing the law. This comes from the Opinions Clause. Don't get me wrong, the president could always remove, okay, if he doesn't like what he hears or if people disobey, but that's very different. I mean, the removal power comes at a cost, and the cost goes up to the extent you think the president doesn't have a right to demand the thing that he's demanding. If you think that officers don't have to, if the law grants the officer discretion, it's their discretion to exercise it, and so on. So in a sense, the power to issue executive orders isn't really a power at all. It's the president just speaking, and the question is the obligation of other people to obey. Principal officers must obey demands for information, and then under statutes, of course, statutes leave lots of discretion, including to the president, and in that respect, the president could be merely executing the laws Congress has enacted. But in the strict sense, it doesn't seem to me to be an exercise of power at all. I'm running out of my opening time, so let me just make one observation, which is, isn't that true of everything else the president does in foreign affairs too? Right? Is a statement of foreign policy, the Monroe Doctrine, the Neutrality Proclamation, the executive agreements, are those actually powers? Or is it just people expressing opinions, the president expressing an opinion? And don't get me wrong, people listen when the president expresses an opinion because of a presumption that there's power to back that up. But ultimately, whether there's power to back up the Neutrality Proclamation turned out to depend on whether Congress enacted the Neutrality Act in 1794 or not, right? Whether Monroe Doctrine has any effect depends on whether Congress is willing to declare war or vary trade regulations. Whether executive agreements have force and effect depend on what Congress has delegated to the president, for example, sanctions, to vary tariffs, for example. So in the strict sense, it seems to me that both in the domestic sphere and a lot in foreign policy, these things that we call executive orders or executive agreements or statements of policy really is just talk. And the question of the constitutional power to back that up, I think, has to kind of come from somewhere else: Opinions Clause, statutes, delegations, and so on. So let me stop there, and I look forward to the discussion. Thank you.
Wonderful. Okay, well, next we'll move to Professor Pierce.
Well, thanks very much for inviting me to participate in this. If people were hoping to hear a robust debate, they might be disappointed because I didn't really hear Professor Werman say anything that I disagree with. So let me just start there and go through some of the basics of what little case law there is on the effects of executive orders. In the vast majority of circumstances, historically, presidents have issued executive orders that are directed to the officers who work for him, and the executive orders are not reviewable because they don't actually do anything that has any adverse effect on anyone. The agency typically, the officer typically responds affirmatively to the order by complying with the order. And then we get judicial review of the agency action through application of the familiar doctrines of administrative law and the Administrative Procedure Act. However, President Trump has done something, it's not unprecedented, but he's done it to a much greater extent than have any of his recent predecessors. He has issued direct presidential orders that have effect on their own. They don't have to go through an agency, and that has some immediate, well-known implications. The president is not an agency, so the administrative law doctrines do not apply to him. The Administrative Procedure Act does not apply to him, and there's only just a little bit of case law out there on what the president can do directly and on how courts should approach it. And we're left with a wide variety of open questions. I have many more questions in this on this topic than I have answers. Certainly, I have very few answers that I can back up with citations to the very few cases that exist that have any relevance. Here's a few questions. There are, according to an inventory made by the Brennan Center that you can find on their website, there are 127 statutes that confer extremely broad power on the president, and the only condition to exercise the power in the vast majority is the existence of an emergency. What President Trump has been doing on a very regular basis is declaring a wide variety of emergencies and exercising these powers. And so one of my first questions is, does the non-delegation doctrine apply to these 127 statutes that confer very broad discretionary power on the president? We don't have any applicable law on that. Related to that, what are these declarations of emergencies reviewable? If so, what's the standard of review? I don't know the answer to that. Here's another one. Does the very powerful version of the major questions doctrine that the Supreme Court applied in 4 cases in 2021 and 22 have any application to any of these executive orders? I would think that an executive order that has the effect of reducing the value of assets in the United States by between $6 and $7 trillion might qualify as an action that has the kind of significant economic and political effect that calls for application of the major questions doctrine, and for a decision by a court that says you can't do this because we are not willing to attribute to Congress an attempt to delegate this kind of extraordinary power in a statute that is just broadly worded old statute. So that's another big question. Now, we did get the beginning of answers. So over the next couple of months, we're going to get answers to a number of these questions. Unfortunately, they're going to come on the Supreme Court's emergency docket. And I don't fault the court for that. This is being forced on them by the president. They don't have any choice but to decide these cases on the emergency docket. But it's really a shame because like the rest of humanity, the justices do their best work when they have the opportunity to reflect, to research, to think, to get the views of a lot of other people. And that requires a matter of years and preferably a percolation of the issues up through multiple district courts and multiple circuit courts. So you get the views of a lot of smart judges coming from a lot of different directions before you make a decision. That's not possible on the emergency docket. They just have to make very quick decisions. And they also have little opportunity to provide explanations. Sometimes there's an opinion. Even when there is an opinion, it's usually just a couple of paragraphs long and not very informative about the reasoning process that came before the decision. But we did get one that has real meat in it that I think is giving us some indication of where the Supreme Court is going to go in each of these cases, and that's in Trump versus JGG. That is the case in which Trump invoked the Alien Enemies Act of 1798 based on a declaration that there had been an invasion of the United States, at least by Venezuela and perhaps by lots of other nations whose citizens have invaded the United States over the last few years. And so there were a lot of questions raised in that case. And the most important take that I have from it, there was a very important venue decision that said that venue lies in Texas rather than in the District of Columbia. And that's very important as a practical matter because the judges in those two forums do differ a lot in terms of their perspectives on many of these actions. But the most important parts of the opinion to me are the parts where the court held that anybody who is deported under this law or presumably even held captive under this law must be given due process, must be given notice and an opportunity to defend, and that the act the actions are reviewable by a court. And so I can just imagine how these cases are going to evolve, how the hearings are going to evolve, where somebody, I don't know what forum it's going to be, but some forum is going to have to decide, did President Maduro order an invasion of the United States? Is this person one of the members of the invading force that Nicolas Maduro sent to the United States? And these are going to be really interesting questions to see them unfold. And I'm interested both in the attitude that the courts take in reviewing all of these actions, as well as the attitude of the public. We don't know much about the people who are being held in Texas at this point under the act. One source reports that 8% have been convicted of violent crimes, 30% have been convicted of some offense, although some of them are traffic offenses, and 70% have never been convicted of anything. I don't know if that's true. Frankly, ICE has not been forthcoming with much information about them. But all of that information is going to unfold over the next few months. And during that time, by the way, one of the things that's real clear is this is a real blow to President Trump's effort to engage in mass deportations. If he's got to have, if there's got to be a hearing, a due process hearing in each case, and it's all subject to judicial review, it's not going to go fast. It's going to go very slowly. So that's all I have to contribute initially.
I guess it's on to me. I've already heard so much I could probably go on for an hour, but I'll keep this short and I'll speak at a high level. I've heard some things that I agree with, some things that I disagree with. So Elon's comment that executive orders, aren't they just really talk or an opinion? I really disagree with that. And he actually pointed out the reason why I disagree with that, which is that anybody, a cabinet secretary who says, oh, thanks for your opinion, I'm going to put that in the round file, will be fired on a Truth Social entry immediately. This president has no qualms about doing that whatsoever. I agree with Richard. By the way, it's a pleasure to be with both of them and with Beth. That, look, Congress has delegated a lot of authority to the president, perhaps, and some of those issues are going to be playing out, perhaps with tariffs, others. And that some of those delegations will raise non-delegation doctrine issues. Supreme Court has been very reluctant about weighing in on the non-delegation doctrine. They came close in a case a few years ago involving the Sex Offender Registration Act, SORNA, but they walked right up to the line of invalidating a statute under non-delegation doctrine grounds, but then they declined to do so. But now let me step back. So executive orders, there have just been a flurry of executive orders, and then we can get into the specifics. Richard talked about one of them having to do with, this one involving Tren de Aragua and the invocation of the Alien Enemies Act. I don't agree that it is going to gum up the works nearly as much as he does, for reasons that during Q&A, if people are curious about, I can talk about. But they have been on everything: birthright citizenship, the death penalty, things involving transgender athletes in college sports, DEI programs, you name it, targeting particular law firms. I mean, you name it, and there have been executive orders all over this place. This president said that he wanted to drain the swamp during his first administration. He clearly felt very frustrated that he was unable to do so. And he has decided this time he's going to double down, and he is trying to shrink the size and scope of government at a dramatic pace, clearly previously, an unprecedented pace. This has engaged a lot of litigation, surprise, surprise, in the bluest of blue states. And there have led to, for instance, a lot of nationwide injunctions. Richard correctly pointed out that the Supreme Court is having to decide issues on its emergency docket, and without adequate percolation. One of the reasons why there hasn't been adequate percolations is because you have district court judges entering nationwide injunctions. I actually think that one can make a very serious argument that nationwide injunctions are inherently unlawful because they deal with non-parties for whom there is no asserted case or controversy, but they've been doing it at a rapid rate. To give this some kind of perspective, 2/3 of all nationwide injunctions that have ever been issued were issued against the Trump administration during his first term. There have already been, in a scant 3 months, 17 nationwide injunctions entered against the Trump administration. To put that in perspective, during the entirety of the 4 years of the Biden administration, there were only 14 nationwide injunctions. These cases are going up to the Supreme Court at a rapid rate, and I think the Supreme Court is starting to pivot. So the first big splash was it was a district court judge here in the District of Columbia that ordered $2 billion of USAID money to go out the door. Or an emergency request for a stay was put up to the Supreme Court. That request was denied by a 5-4 vote. So the $2 billion left. That engendered a huge amount of criticism, saying that this was not really granting equitable relief. It was really providing complete relief in a way in which, if the government prevailed on its arguments about sovereign immunity, et cetera, they would never be able to recoup those funds. So now you are getting cases coming up that are having a slightly different twist. So one of them was the JGG case, which Richard just talked about, saying, no, you really can't assert sort of a class action under the Administrative Procedures Act, that you're claiming you were unlawfully detained. We have a procedure for that. It's called habeas corpus, and you have to file your habeas petition in the area where you have been detained. Yes, we're going to make it quite clear that you're entitled to notice and an opportunity to be heard, but that's where you're going to be litigating these cases. There were a couple of other cases that just came up in which you saw a flip, particularly by Justice Barrett. There's one case that just came out, OPM versus AFGE, in which the court overturned a TRO that was granted by Judge Alsop out of San Francisco and said, yes, you can fire over 16,000 probationary employees. And if you are an aggrieved employee, you can go not to district court, but you can go to the Merit Systems Protection Board. Similarly, again, by a 5-4 vote, that Justice Barrett flipped. They just had Department of Education versus California, in which they said, yes, Department of Education, you can terminate DEI grants to various schools. if you are a program manager or somebody who had a contractual arrangement with the Department of Education and you think you've been aggrieved, you can't go to district court. There is the Tucker Act. You can go to the Court of Federal Claims. So I think that there is some pushback on this. The reason Donald Trump is doing all of these executive orders is he has the thinnest of thin majorities in the House of Representatives, so he's not sure he can keep everybody together in order to get legislation passed. And in the Senate, he has a 3 Senate majority, but there is the filibuster that is there. And the only time you can get around a filibuster, since there's no way he's going to get 60 votes on any of these things, is either reconciliation or the Congressional Review Act. Those are the only things in which that are not subject to a filibuster. So he is entering executive orders and inviting these challenges. Now, this topic for today was basically, is he legislating or not? A number of these challenges are directly taking on Congress. So he is pausing funding. He has Doge in there doing all of this analysis, saying there's waste, fraud, and abuse going on at a rampant level. He is threatening to rescind these things. This will eventually lead, I think, to a challenge to the constitutionality of the Empowerment Control Act of 1974. You're getting lots of challenges for Humphrey's executor in terms of the removal authority. So one of these cases is going to go up to the Supreme Court next. So there's a case involving Gwynne Wilcox, who was on the National Labor Relations Board, another involving Kathy Harris, who was on the Merit Systems Protection Board. Their statute only calls for for-cause removal. President said, I don't care. I don't think you're going to implement my policies. I am firing you. They have filed lawsuits. A district court judge ruled in favor of Ms. Wilcox and Ms. Harris. A panel of the DC Circuit stayed that. An en banc panel has just reversed that stay. There is a dissent, ringing dissent from Naomi Rao that says, no, I think that Humphrey's executor has effectively been overturned. Well, guess what? That is now going to be challenged. You have other challenges. He has now ordered independent agencies to submit their regulations to the Office of Information and Regulatory Affairs. That is unprecedented. So that is going to be a challenge. The tariffs, Richard alluded to the tariffs, right? There's a whole question about whether this presents a major question under the, what is it? It's the, under the International Emergency Economic Powers Act, IEPA, that the New Civil Liberties Alliance has filed a lawsuit talking about that very thing. And so we will see where that goes. Immigration enforcement, that is a direct challenge to a congressional authority. He fired 17 inspectors general. There is a statute that said that before you can fire an inspector general, you are supposed to give Congress 30 days notice. He quite intentionally did not give Congress 30 days notice. He wants to be able to say, this is an inherent executive Article 2 authority. I get to do it. I don't have to notify you. So there are all kinds of challenges going on. We could talk individually about every one of these executive orders. You could have a separate webinar on those. It would keep the Federalist Society busy for a year. But with that, let me sort of stop, and we can dig into the merits or demerits of any of these executive orders, perhaps through Q&A.
So that's terrific. And I want to give all of you a chance to respond to each other. But as you're doing so, maybe consider the question, which I think a lot of people have, which is, are these executive orders different in kind than prior executive orders? And do they kind of evince an idea of greater power than prior executive orders, or other methods of ordering something would? So for example, if the president before could just pick up the phone and call the attorney general and say, I would like the policy to be that you seek the death penalty in every appropriate case, is it fundamentally different in any way, in any legally meaningful way, if he does that through executive order, or is that just more of a messaging function? So let me give you a chance to respond and then also consider that question.
I'll let my fellow co-panelists go first.
Great. So I'll get us started and try to address a few things, including I see there's a question on the major questions doctrine, and I don't know that I quite agree. So in terms of whether it's different in kind, yes and no, but ultimately no. The no part of it is, executive orders have this boilerplate language at the end that says, nothing in this order is intended to be inconsistent with applicable law or change applicable law and so on. And so they recognize that these orders basically direct officers, the agencies, to exercise discretion in a particular way, but they must have that discretion under the law. What's different is the number of of executive orders that do challenge congressional statute on the ground that the congressional statute interferes with some presidential prerogative. Okay, and so in that sense, it's not new. Andrew Johnson, I mean, he got impeached for it, wasn't convicted, but refusing to follow the Tenure in Office Act, trying to fire Secretary of War Ed Stanton, who barricaded himself in the office. That's what they claimed. We don't have authority to disobey laws of Congress that we think are unconstitutional unless they invade executive prerogative. There's a lot of that going on right now, right? And so I think that explains the removal stuff, which is like a substantial number of the orders. So in that sense, it's new, just the aggressiveness with which presidential prerogatives are being asserted against existing congressional statutes. Okay, but when we're not dealing in that space, it's not novel, right? All these orders are supposed to be interpreted consistently with applicable law. They don't create any new rights, benefits, and so on. Let me say something about the major questions doctrine, because this might be a good test case as to whose theory of the major question doctrine is correct. So I wrote a paper called Importance and Interpretive Questions that's very similar to what Justice Barrett then sort of adopts in concurrence in Biden against Nebraska, where she claims that it is sort of this linguistic canon, not this substantive non-delegation enforcing canon. I think that's mostly right. In my view, the major questions doctrine is only triggered when there's an ambiguity. Okay, not just when there's a broad statute. So lots of agencies get statutes that say, make national ambient air quality standards requisite for the public health, right? It's like, okay, well, that's a pretty broad delegation, can have lots of economic impact, but the delegation is broad but explicit, but express. Okay, the major questions doctrine, in my reading of the cases, tends to be invoked, okay, when the statute itself is amenable to two different meanings, and so there's an ambiguity. Is the best system of emissions reduction the technological process within the fence of a plant, or is it like the national energy system? That's an ambiguity. The statute could mean X or it could mean Y. Those are two different possible meanings. And if Y, the interpretation Y is going to have a major political and economic consequence, then we're going to be suspicious of whether Congress intended that result as opposed to X, which is the other available reading of the statute. But whether the Emergency Powers Act, the Trade Expansion Act, the national security tariff stuff, I don't know that it would fit comfortably in major questions, because those are quite express. Those aren't particularly ambiguous. It's not like, oh, the Congress could have meant X when it used this word. No, Congress just delegated a bunch of authority in most of these statutes. And so I think it's ripe for a non-delegation challenge, not a major questions challenge, which is, again, is a statutory interpretation approach before you get to a non-delegation. But if there's a clear and express statement, even if it's broad, doesn't have to be on the specific issue, then I think that becomes a non-delegation problem. And now tariffs, foreign affairs related stuff, there's a foreign affairs exception to non-delegation. A lot of people say, yes. I'm like, I don't know. The Constitution gives Congress all those powers, but that's for another discussion.
So Professor Pierce, is Professor Werman right that Congress, to the extent this is a problem, Congress created all these problems by delegating all their power away to the executive branch?
Well, that's one way of thinking about it. My concern is we don't have a legislative branch anymore because of extreme political polarity and party-based primaries. It's impossible to do what used to be done routinely before, enacting statutes. Frankly, the best that Congress could do in the vast majority of circumstances was to enact broadly worded statutes. I do agree with Elon's response to your question. I think he got that just right. Your illustration is a good one. Beth, your illustration is a good one, illustration of something that's really not different from the telephone call you hypothesized. But a whole lot of the other actions are dramatically different. I just had 3 points I wanted to make briefly in response to John's discussion. First, on the Department of Education versus California opinion, what it looks like is they're going to shuttle all of the grant and cancellation and contract cancellation cases over to the Court of Claims. That's going to be really interesting to watch. I know that court well. It's a tiny little court, blocked from the White House. My daughter clerked there 25 years ago. There's no way in hell it can handle that kind of a workload. And the rules on cancellation of grants and contracts are very, very complicated. The government can cancel them if it follows the right procedure, but then there are enormous implications to each cancellation. The government winds up having to pay a whole lot of money to the grantees or parties to the contract. So it's going to be really interesting to see how well the Court of Federal Claims can handle the load that the Supreme Court has handed it in that case. Now, you also referred to the case that was just dismissed yesterday, that the government just won yesterday, involving all of the OPM firings. That was just a routine standing holding, and I think the court was absolutely right that the people who brought that case didn't have standing. The bigger test is going to come in the much larger case that is about to go before the court, in which it was the attorney generals of all of the democratically controlled states who were the petitioners, and they have a pretty good claim to being injured in fact. So I think they'll be able to get by the standing hurdle. And so then the court is going to have to say something about the merits of the filing cases or the jurisdictional implications of the filing, the firing cases. And that case also brings to mind a problem with the argument that judges should not have the power to issue nationwide injunctions. I haven't been part of that debate. There's some very, very good scholars who have developed very lengthy, complicated arguments on each side of that, and I have not participated in that debate. But one thing comes to mind that I think would be problematic. 24 of the motions for preliminary injunctions so far have been filed by the attorney generals of the democratically controlled states. And if the injunctive relief is limited to the parties to the case, then what you're going to wind up with is a whole lot better treatment of a lot of individuals and institutions in democratically controlled states than in Republican controlled states. And that strikes me as an extremely problematic consequence of the only viable alternative to national injunctions, that is, injunctions that apply to the parties to the case. So without taking a position on that, I do flag that as, I think that's going to be a very difficult issue for the court to address.
Let me address a couple of things very quickly. One thing I'm going to push back on Richard's comment. The case out of California, the court said that the groups that were purporting to represent aggrieved parties, that they lack standing, but there were also individual challengers in that case, and they said that those people have to go to the Merit System Protection Board. There are still other cases, including one out of Maryland, raising these same issues, but I think the court has already tipped its hand as to where it is going to go with that. I think that if you ended up having a case in which an injunction was issued in which several states were granted relief as aggrieved parties, that would be on a fast track to the Supreme Court. Also, I would note that there are several legislative proposals by Darrell Issa, Chuck Grassley, Mike Lee, that are trying to amend that are trying to create for nationwide injunctions, that anybody who requests a nationwide injunction in order to avoid judge shopping, goes to a randomly selected 3-judge panel with a direct appeal to the Supreme Court. Assuming nationwide injunctions are lawful at all in the absence of a class certification, that at least would help alleviate that problem. I want to answer the question that you originally posed, Beth, which is whether this is somehow different than what other presidents have done. I think it is different only in terms of the scale at which it has been done. But if you look back, for instance, when President Obama said, I'm going to use my phone and my pen if Congress doesn't act, and then with the swoop of his pen, basically through executive order, did DACA and DAPA, that to my mind undid enforcement of our nation's immigration laws, or Joe Biden with the swoop of his pen, said that under the HEROES Act, he could forgive, I forget, it was billions or trillions of dollars in student debt, or impose a vaccine mandate on individual employers, or have a nationwide eviction moratorium. Those were certainly breathtaking in their scale, and the courts pushed back on them, at least Joe Biden's executive orders, not Barack Obama's executive orders.
Well, we're fortunate. We've got a terrific audience and we've got a lot of great questions in the chat. So I'm going to turn to one of the questions from our audience, which is about the questions of declaring an emergency, because a lot of these executive orders are premised on the president declaring an emergency, and it's the statutory predicate for many economic sanctions. And so will seeking review of declarations of emergency look partisan or ring hollow is the question from the audience, now that that's the basis of a lot of these executive orders. And I guess underlying that too is who, if anyone, reviews what is an emergency?
It's a very good question. I don't know how it's going to be perceived. The one thing I will note is that the first group to file a lawsuit challenging these tariffs and raising the major questions doctrine is the New Civil Liberties Alliance. The New Civil Liberties Alliance is not a liberal organization by any stretch of the imagination. It's a close question. So the argument that this is a major question is that that IEPA, again, the International Emergency Economic Powers Act, in the past has been invoked for very specific emergencies involving clear hostilities by an enemy, and has been limited to particular transactions, thinking of freezing Iranian assets, during a hostage crisis, that sort of thing. And that Congress has constitutional authority when it comes to, taxation and tariffs under Article 1, Section 8, and that the major questions doctrine sits there and says, if it's going to have something of major economic ramifications, that the court will, as Elon said, be skeptical that Congress had that in mind. And the only way you overcome that skepticism is that Congress has to express its intent clearly in the statute, which it hasn't here. That's the argument in favor of this being a major question. The argument on the other side is one you just raised, which is IEPA doesn't define the term emergency. It also says that Congress, once they are notified that IEPA has been invoked, can terminate. They can vote to terminate that emergency. And it also lays out in the statute certain things that a president cannot do. Imposing tariffs is not one of the things that a president cannot do. And if one wants to look at history, the predecessor to IEPA, which is the Trading with the Enemies Act, President Nixon invoked the Trading with the Enemies Act in order to, guess what, impose tariffs. Now, Richard raises the flip side, which is that if this is such a broad delegation of power, saying basically, you define an emergency, you impose what you want, go to town, that raises serious non-delegation, non-delegation doctrine questions. So as happened during the first Trump administration, we're going to see a lot of very interesting law made, and a lot of it is going to be testing the scope of executive authority, which is exactly what this president wants to do.
Professor Pierce or Worman, do you have a view on the question of emergencies and the presidential declaring one as the basis for executive orders?
The only thing I'd add there is I generally agree with John's analysis. I do think some of the statutes do identify with greater particularity the nature of the emergency that has to arise, which might protect the statute from a holding that it violates the non-delegation doctrine, but also might encourage a court to get involved in the review process. And the enemy aliens statute of 1798 is a good illustration. It is available only in a particular type of emergency, one of two types of emergency: war or invasion. And President Trump has not claimed that we are at war. He has claimed that we have been invaded. It wouldn't be surprise me if courts get into the process of reviewing his determination that we have been invaded.
I'm going to I'll push back a little bit on that. It's hard to tell exactly what a court is going to do in terms of reviewing the Alien Enemies Act invocation. But, that talks about a declared war between the U.S. and a foreign nation or government. Clearly, we don't have declared war. Or any invasion or predatory incursion is perpetrated, attempted, or threatened. Now, the executive order is limited to Venezuela. It clearly articulates that the Venezuelan government is working hand in glove with Tren de Aragua, which is a Venezuelan-based gang. And the question becomes whether a court is going. So the court in the JGG case said, look, there are going to be matters of interpretation. You can test the constitutionality and you can test the applicability of the statute. I think the courts have traditionally been very, very reluctant, or they should be reluctant. They don't sit in the Situation Room, or they don't sit in the National Security Council, the second-guess presidents in terms of, what the relationship is between Tren de Aragua and the Maduro government. There is a Supreme Court case that was cited in the JGG case called Ludke versus Watkins, a 1948 case, in which the court said that the Alien Enemies Act, and this is a quote, is a statute which largely precludes judicial review. I certainly think that they're going to be habeas petitions because the order says this applies to Venezuelans, it only applies to members of Tren de Aragua, it only applies to people who are over 14, it only applies to people who aren't permanent, residents. So if somebody goes in and says, hey, I'm 13, or hey, I'm El Salvadorian, I'm not Venezuelan, or hey, I'm a member of some other gang, but I'm not a member of Tren de Aragua, or I am a permanent resident, those will be applicability things. Do you fit within the four square corners of that executive order? On the other questions, somebody can talk about the constitutionality of the Alien Enemies Act. Good luck with that. On the other questions of interpretation, we'll see what courts do. But I think they're going to, particularly in light of the Supreme Court precedent, the Ludke case, which I just talked about, will tread lightly, or at least they should.
So we have another question asking about the current Supreme Court and the different justices' approach. And the question is, what do you think explains Justice Barrett and Justice Roberts' seeming lack of consistency in ruling on the legality of the Trump executive order? So I guess the preliminary question is, do you think that they have been consistent? And I guess, what do you think is in general, the courts or different justices' approach to looking at executive orders? Or do you think it really kind of depends on the order?
Happy to let my fellow panelists go.
Yeah.
I have a problem with the predicate for the question. I don't see any inconsistency at all. And I think all of the justices are striving to be consistent. Consistency doesn't mean you consistently side with the conservatives or the liberals, or you consistently side with the president or with the parties who are on the other side from the government. Consistency means that you apply the law consistently to all the parties as you see the law. And that doesn't surprise me that some justices go from favoring the government to being on the other side on these issues. And those to me are potentially entirely consistent decisions.
I actually disagree with that. I think with the exception of Justice Barrett, they've been entirely consistent, which is you have these lower court judges that are entering these very, very broad orders. They are granting TROs. And the problem has been the TROs are normally considered to be not appealable. And so you have Elena Kagan, Sonia Sotomayor, Ketanji Brown Jackson, all saying, hey, these are TROs, are not appealable. What's the hurry? The government will be fine. And in the meantime, people are suffering pain, and that's what we have TROs for. You shouldn't be issuing these stays. You have the Chief Justice Roberts, who has consistently been saying that he would deny a stay, so he would allow those TROs to go and then turn into preliminary injunctions, permanent injunctions, work their way up the appellate process. But he is not joining in any of the robust dissents by the 3 Democratic appointees. And then there's Justice Barrett. Justice Barrett sided with the Chief Justice and the 3 Democrat appointed justices in the USAID case. And I think that she is tacking in a different direction now in the cases that I cited earlier. So I think with the exception of Justice Barrett, who appears to be perhaps changing her views on these subjects, they have acted so far entirely consistently.
The only thing I would add to this is that it's just hard to know. I agree with Professor Pierce that as a general matter, I think judges try to get it right. And we would know more about why Justice Barrett or Chief Justice Roberts is doing what he or she and he are doing if this didn't come up in emergency posture, such that we have to divine what they're doing based on very little data and information, which is just a way to bring it back to the question of universal injunctions, because Professor Pierce's point is well taken about how people would be differently treated in different jurisdictions, but that's always true, right? Depends on which judge you get, where you file suit. But that's what allows these cases to percolate. It's why if there is an injunction, the Supreme Court doesn't have to get involved at an early stage because it only applies to particular parties. And John, I agree that John didn't really address this, but he flagged this, and I think it's important to talk about. I don't even know if Congress granted the power to give this, that would be constitutional. There's some argument that they did in the APA, that the set-aside language in 706 does that, but if that, I don't think it, I'm actually not sure that it does, but if it did, like, would that be judicial power? In the same sense that courts don't erase statutes from the statute book. The bankruptcy law that was struck down in Stern v. Marshall was still there last time I checked the U.S. Code, actually, which is kind of interesting, but that was a while ago. They just refuse to apply them in the cases before them. And so, okay, how do I universally set aside an APA, a rule made under the APA? Do I delete it from the Federal Register? No, I just don't apply it in future cases, but I will not apply it when that future case arises. So I just don't know that there is even a power to grant these injunctions if Congress wanted to, setting aside the question of whether it is.
I can just add one, and this is take a second. I agree completely with what Ilan just said. At one time or another, a majority of justices have at various times decried nationwide injunctions and said how inappropriate they are. I think it is entirely possible that if Congress does not adopt one of these proposals, something that's going to be very difficult to do in a politically poisoned environment since the filibuster exists, I do think that either the Supreme Court is going to do what it's doing now, which is setting them aside by saying, no, you go to habeas petition, you go to the MSPB, you go to the Court of Federal Claims. They can sort of lift these nationwide injunctions one by one, or they will weigh in and say, this violates the Constitution because there is no case or controversy with respect to non-parties whenever you issue these injunctions. So I do think the court is either going to continue to punt and duck and cover, or they will weigh in.
Well, if we could do a whole day or week on nationwide, or as I think Justice Gorsuch called them, cosmic injunctions once, because they're limitless, and the set aside under the APA. So I think that actually the Executive Branch Review Conference is going to do a session on that coming up, and look forward to that. But we're at the end of the hour. So I just want to thank our panelists, John Malcolm, Ilan Werman, and Richard Pierce. Really terrific conversation. And thank you to the Federalist Society for hosting.
Yes, thank you. Thank you so much, Beth, and thank you all. And on behalf of the Federalist Society, I want to thank our audience members also for joining us. Please check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming webinars. We hope to see you all at our Executive Branch Review Conference on May 7th at the Mayflower Hotel in DC. Registration for that, once again, is on our website. Thank you once more for tuning in, and with that, we are adjourned.
Thank you.